Thank you for joining us today for Jennifer Schaus and Associates in our Webinar Wednesday program, coming to you live from Washington, D.C. We are uncovering each part of the DFARS, or Defense Federal Acquisition Regulation Supplement, every Wednesday at 12 p.m. Eastern. As you know, the DFARS are the rulebooks for contracting with the Defense Department. We've been moving sequentially, so we started with DFARS Part 201 in January, and we'll be finishing with Part 253 in December. Our webinars are every Wednesday and are provided complimentary. They are recorded and can be downloaded from our website and YouTube channel, which now holds over 450 of our government contracting webinars. In the interest of time, we do not take questions, so if you do have questions for our speaker, we will have his information on the last slide of the presentation today. Virginia PTAC at GMU offers free one-on-one counseling to firms in Virginia on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on business location. If you're interested in learning more, please use the links provided to explore what PTAC can offer. Set Aside Alert provides up-to-date news, information, and opportunities for small business federal contractors. Their daily opportunities alerts assure you won't miss important sources sought and solicitation announcements, providing details so you can jump on the hot ones. Every 2 weeks, they deliver concise breaking news, events, regulations, and teaming opportunities. Please join the Reston Chamber of Commerce Government Contractors Council for regular meetings. And you can contact Alicia Fields with the email shown on your screen if you have any questions. Federal contracting is a relationship game. Now get in front of your federal human sooner with the exclusive Players and Layers method from Judy Bratt and Summit Insight. Connect with her on LinkedIn and find out more, or visit growfedbiz.com today. Okay, and now a little bit about us. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles in compliance, and more information can be found on our website. I wanted to highlight an additional webinar that we're holding this year. The title of the webinar is Fiscal New Year Kickoff, Best Practices, which will be on October 1st at 12 p.m. Both the sponsor link and registration link can be found on your screen and on our website. Our speakers will be covering market research, marketing, sales and capture, proposal writing, and compliance. Sponsorships are available. Please email hello@jenniferschaus.com for pricing details. I also wanted to inform you of a new series that we're holding this year. We have launched a monthly series called the Govcon Live Q&A Cafe. This is a live webinar series held each month, and these will take place on the second Friday of each month this year at 12 p.m. Eastern. We have assembled a group of 4 panelists who are subject matter experts on a specific federal contracting topic. The panelists will make a short presentation about the topics listed here on your screen, and then take your live questions about that topic. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available. Please email hello@jenniferschaus.com for a media kit with pricing details. Also, please note that you can use code DFARS for a $15 discount on each of these webinars. So to go into a little bit more detail, next week on August 13th, our speakers will be covering compliance, and that will be with Jacob, Ryan, Rebecca, and Mark. In September, our panelists, Rena, Troy, Deborah, and Andres, will be covering oral presentations. And then in October, our speakers will be covering set-asides, and that will be covered by Anna, Eric, Sai, and Tim. On November 12th, Michael, Marcia, Tracy, and Jeff will be covering pricing. And lastly, in December, Our speakers Shirley, Joshua, Kate, and Brad will be covering M&A. And now to introduce our speaker, Lewis Rhodes. Welcome, Lewis. We are glad to have you here with us today, and I'll now turn the floor over to you.
Hi, thank you, Hunter. I appreciate it. Happy to be here. I think I need to either update my picture or shave and grow some hair back because I look much better in that photo than I do in real life. So I'm an attorney, run the government contracts practice here at General Counsel PC. We are nearly a full service law firm. We can do most things that anyone needs, from employment to litigation, corporate, obviously government contracts, which include bid protest and your various agreements and claims. We also have a family law and trust and estates practice. So we work with business owners holistically, hopefully avoiding the family law issues. But that's me, and that's our firm. Feel free to reach out if you have any questions regarding these topics or otherwise. We can flip to the next slide, please. So as Hunter said at the beginning, we're covering DFARS Part 233 on protest disputes and appeals. That's going to be the topic here. The DFARS is a little bit light on this information, so we're going to kind of rehash some of the stuff that's out of the FAR. But frankly, this is the type of information that it never hurts to hear multiple times. Next slide, please. All right, so when we get into the DFARS and we talk about DFAR versus the DFARS versus FAR, all right, and I'm sure if you've attended anything in this series, I'm repeating things you've heard repeatedly. The DFARS are a supplement, right? It supplements the info in the FAR. It doesn't replace the FAR. It doesn't change or alter the FAR. It adds agency-specific requirements into the procurement process. So the FAR is the big thing, Federal Acquisition Regulations. It applies cross-agency throughout almost all the government. All right, there's certain other agencies that have their own specific set of regs, like NASA, the Postal Service. Those regs, even though they're different, are still very similar to the FAR. They're structured and organized the same way. But the FAR is kind of the big umbrella mothership. The DFARS are individual supplements that goes to the DoD. Other agencies have their supplements as well. It just adds some fidelity or details and a little bit of different info into the FAR requirements. And as I said here, in the DFAR section 233 is really minimal. In fact, I have it open on my other screen, and on the protest section, there's exactly two sections in the DFARS. The rest of it just ties back to to FAR Part 33. So that's kind of how the interplay is. You always want to look at the agency supplement, but understand in most instances you're going to be dealing with the FAR across the board. Next slide, please. Okay, so we're going to get into protests a little bit here, and one thing I do want to cover ahead of time, and I was remiss in not putting this in my slide deck, is there's a current rulemaking going on related to enhanced debriefing procedures. If you're at all involved in bidding with the DoD, you'll understand that back in 2018, DoD came out with the enhanced debrief. So after you have your debrief, you can submit questions to the contracting officer within 48 hours of your debrief, and then the government has 5 days to provide a written response to your enhanced debriefing questions. Now, this is a DoD specific class deviation. It was issued by the DoD back in May of 2018. They have a supplemental DFARS rule going through the rulemaking process that's going to add a third section to DFARS section 233.1 that's going to specifically encode this in the regulations talking about your enhanced debrief. So debriefs are important because they start our protest clock, and we'll talk about the timelines here in a couple of slides. So what is a protest? Protest by regulatory definition, it's a written objection by an interested party to a procurement activity. All right, this is where you go in and you say, hey, I want you to cancel the award. I want you to award it to me. I want you to, terminate the award. I want you to go back and re-examine stuff. This, like it's called, it's a protest. You're protesting what the government did. Now there's two timelines when you get into protest. There's pre-award and post-award. And this is very important to make sure you pay attention to, because pre-award protests the grounds can only be raised prior to the submission of your proposal. I jump up and down. I've taught 15 webinars. I've spoken on panels constantly on this issue. And a number of times we have clients come to me wanting to post-award protest a pre-award protest grounds is disheartening and frustrating. So if you have anything in the solicitation that looks bad, you want to make sure that's a pre-award protest. You don't want to sit on that, because you'll be found to be untimely if you challenge a solicitation ground during a post-award. All right, and the final line on a protest here, you have to allege that the government violated procurement law or regulation in something that it did or didn't do. And more importantly, you have to show how you were prejudiced by that action or inaction of the government. All right, those are some key requirements. So if you've ever read a bid protest letter that's been submitted on your behalf, you'll notice lawyers always make sure that we're writing on how you were prejudiced. There's always a sentence in there that says, but for these errors, you would have had an opportunity to win the award. If you don't put that line in there and you don't claim your protest, your prejudice, your protest would actually would not meet the requirements of regulation and could be dismissed by GAO or one of the other protest venues. Next slide, please, Hunter. Okay, and here's the other key: is you have to be an interested party in the protest. All right, you have to, and I put in here in parentheses and the prime, because I've actually just gone through this with one of my clients. My client is the subcontractor on a procurement that was just awarded to a competitor. My client is really jumping up and down and wants to file a protest because he's not so sure that the government did everything the right way in the award of the potential award of the contract. Unfortunately, the prime is digging in their heels a little bit and isn't very interested in protesting. So if you're the sub, you really have no choice. You're not the prime. The prime is the one who has to make the decision and file the protest. I mean, even in case, I've seen cases where a subcontractor is willing to do all the legwork, pay all the legal fees, do everything involved in getting a protest done, and a prime, for one business reason or another, opts not to do it. Obviously, that's a very frustrating point to be in if you're a sub. But it goes back to just the whole relationship building between a prime contractor and a subcontractor. I know everyone wants to target their opportunities and want to put together good teams. I always encourage my clients to make sure that you have a good relationship when you enter into a teaming agreement, because while you might have a good business team, if the two parties don't get along very well, something's going to go wrong in the process. But outside of being the prime, you have to be an actual or prospective bidder. We talked about pre-award protests a couple of minutes ago. In order to file a pre-award protest, you have to be someone who can bid on the opportunity. That means if it's an SDVOSB set aside and you are a other than small business, you are not a prospective bidder. If it's a WOSB set aside and you're an SDVOSB, you're not a prospective bidder. So you have to be someone who's willing and able and contemplating bidding on the proposal in order to file a pre-award protest. You can't protest as a other than small company. You can't come in and protest that it shouldn't be a set aside. Right? That's you can make those challenges, not in a GAO protest. All right. Now, in a post-award protest, you have to have a direct economic interest to be affected by the award. All right, that means you have to have been a offerer who submitted an offer who is at least eligible for the award. A lot of times when you you file a protest, you'll turn out that the agency will move to dismiss it because based on ratings and pricing, you're the third or fourth or fifth in line. So even if they were to void the award to the proposed awardee, you wouldn't be next in line, so you're not going to be able to advance a protest. Now, there are certain protest grounds that it doesn't matter whether you're second in line or fifth in line. So you just need to be able to make sure you're writing your protest the right way. So if you were an offer and you were impacted by the way the evaluation was conducted, your protest has standing. Now, there's standing, and there's legal standing, and then there's business judgment. I spent about 6 or 7 years as an in-house counsel, and we had a lot of really thorough discussions with the operations side, talking about, hey, technically we can protest this, but there's a big enough gap between us and the awardee in price, and there's 3 other people between us, that even if we win the protest, it's likely to be a Pyrrhic victory, and we're not going to end up with the award. So, one conversation I often have with clients in protests and otherwise is, just because you can doesn't mean you should. What I recommend is, when you're in a protest and you're on the fence about it, reach out and discuss the issues with your counsel, whether it be an internal or outside counsel, somebody who does protest quite a bit. Obviously, I'd love to field your phone calls, but speak to someone. When you filed several dozen or scores of protests and you've been through the process often, I can usually offer insight that a lot of clients don't get to see, just because they don't get to live this stuff day to day. So again, in order to file a protest, you have to be an interested party. It means you have your economic interest, and you have to either be a proposed or an actual offerer. If you're not one of those 2 things, you're going to lack standing to bring your protest. And if you lack standing, the agency will very quickly move to dismiss your protest. Next slide, please. Okay, so the next protest question is where. All right, I keep referring to GAO, and you see GAO in bold and italicized, because that's probably where the vast majority, maybe even 90% of protests end up to one degree or another. So it's what everyone thinks of when they think of bid protest, but it's not your exclusive opportunity. There's 3 different venues where you can bring a protest, and this is under FAR 33.1 and the DFARS 233.1. The lowest level one is an agency. In the past, I've generally told my clients, agency protests are not worth the paper they're printed on. That's kind of changed and changing a little bit. It also depends on the agency. The Army, well, let me back up a second. So when you do an agency protest, you're protesting to the contracting officer. Other people will get involved, but you're basically going back to the same people who made the procurement decision and challenging their decision to them. Okay, generally that's not a very successful way of doing things. But some agencies are starting to tweak how they do this. I think partly to avoid GAO protest and streamline the process internally a little bit. A perfect example is Army. If you're doing an Army bid that's being run out of Rock Island has its own agency protest venue. So if you're going to file a protest with the agency, you're not going to send it to the contracting officer. You're going to send it to a separate department within that contracting command, who's going to take a second look at it. This is a little more, this is a little even more informal than GAO. Now, it doesn't stop your GAO protest, and we'll talk about that in a second. But it's a little bit quicker, and in some instances, you may want to go to the agency because you think it's more likely to get an outcome. And a perfect example of this is about 7 or 8 months ago. I had a client. They lost. They were not selected for an award, and the proposed awardee, however, had a $150 million open legal judgment against them. That clearly, when the Army was doing its evaluation, the Army missed that. You're not a responsible contractor if you've got a $150 million litigation judgment on you. We didn't want to embarrass the Army for various reasons. We didn't want to bring that to GAO and point out that the Army missed something that was pretty obvious. So we filed that protest with the agency, and the agency voided that award. So it was a good opportunity to go to the agency and be like, hey, you made a clear mistake here, and I'm going to give you an opportunity to fix it before I go to GAO and take it outside of your internal office. It is a relationship industry, and why the government doesn't get mad when you protest, it often is the government does appreciate when you do certain things the right way. Now, an agency protest, as I said a few minutes ago, does not stop you from going to GAO. Your GAO protest clock does not start until you get a final decision from an agency. Now, generally, that's the final award decision and your post debrief. Now, if you file an agency protest within the time periods there, your GAO protest clock starts on your agency protest decision, as that decision is the final action of the agency. So if you go to the agency first and you don't get relief, you can still go to GAO. GAO, Government Accountability Office, that is, as I said, where the vast majority of protests go. By regulation, a GAO protest has to be resolved within 100 days. So it's quick, at least in the legal world, 100 days is very fast. If you go to court, generally it takes a lot longer. GAO is fairly informal. There's no discovery. The government has to produce the administrative record. Your attorneys look through the administrative record, and then they, under a protective order, so we can't share everything in the record with you. We can give you a general sense of what's in the record, and then you carry on with your protest, or you can withdraw your protest if after reviewing the record you realize that there's no argument there. GAO, like I said, everyone likes GAO because it's generally cheap, and it's generally fast and informal. Now, GAO protests can get fairly large. Once upon a time, I worked on a $32 billion acquisition that was protest. That's 32 billion with a B. It was actually for making nuclear weapons. That protest ended up having a 10-day hearing. That is the absolute extreme of a GAO protest. It is actually the only GAO protest I've ever had a hearing on. The numerous other ones are just relied on paper. Your other venue for protests are Court of Federal Claims. There's a misperception out there that you can appeal a decision at GAO to the Court of Federal Claims. That's not 100% accurate. Court of Federal Claims has de novo protest jurisdiction. That means they look at it fresh. They're not taking GAO's decision and evaluating whether GAO was right or not. If you file a protest at GAO and lose, you can then take your protest to the Court of Federal Claims. Court of Federal Claims has a 1-year jurisdiction window on when you can file your protest. So if you file a GAO, lose a GAO, 100 days later, you still have time to go to the Court of Federal Claims. People who do that are generally the very big companies and the very big procurements. I've had that happen a couple of times. Both times I've been involved in that. It involved procurements north of $100 million. Court of Federal Claims is a court. Department of Justice, not the agency, defends the protest. It becomes a much more formal process and read expensive. You have to write a complaint. You don't get an automatic stay at the Court of Federal Claims. You got to file a motion for the stay. There's a little more robust discovery, and then the legal briefings are a little more robust. Now, Court of Federal Claims can also be done well within 100 days, depending on the court's docket. But the odds are GAO is going to be faster than the court. So your order of least to most expensive, least to most informal is agency, GAO, and the Court of Federal Claims. And that's why most people tend to default to the sweet spot right there in the middle where they hit GAO. So that's kind of in a nutshell. I know this has been covered ad nauseum in some other topics. So I'm just kind of touching the wave tops on it here. But again, the important thing to know is if you go to the agency, you can still go to GAO. If you lose a GAO, you can still get a fresh set of reviews at the Court of Federal Claims. Next slide, please. The other big question I often get asked is, can I win a bid protest? A lot of companies feel that, I'm told if I file a protest, I'm never going to win. It's a waste of time and money, and all I'm going to do is make the government angry. So the government generally does not get angry if you protest. Now, if you bring a protest that doesn't really have a lot of support or basis in fact, and it's kind of a sketchy argument where you're just trying to delay things, especially if you're the incumbent, that could anger the government and the agency. All right, if you have a good faith basis to want to challenge some of the agency's decisions, the agency understands that this is part of the way of doing business, so they don't necessarily get mad at you as long as you're doing it you have a good faith basis for your protest. As far as whether or not you can win, the answer is it depends on how you define win. So you can see the number of cases that GAO addresses per year roughly in a bid protest, right? Back in 2017, it was nearly 2,700 cases. 2020, it dropped substantially. I think we can all understand that even though it was trending down, I think it dropped a lot more due to COVID and a lot of other procurements being delayed. So that's one of the reasons you saw a lot less bid protests in 2020. Now, sustained means you win your protest straight up. The government issues, the GAO issues an opinion that says the protester's right, government, you messed up. You need to go back and redo something. So that happens, roughly 15% of the time. And, so again, in the big picture scheme, if you want to say on a decision, yeah, you're only likely to win 1 out of every 8 protests that go all the way to decision. However, there's this issue called corrective action. And we see the government taking corrective action in response to a protest. This means I file a protest letter, I challenge something the government did in the protest. The government reads my protest letter, their agency counsel gets involved a little more thoroughly, looks back through the record and says, you know what, the protester has a point. We're going to go back and relook at this. We're going to reassess past performance. We're going to do a new technical evaluation. We're going to do something. And that generally something has to tie to your protest ground. That happens, and you'll notice that the agencies have had an uptick in the amount of times they're taking corrective action. It goes from, it usually hovers into 30 to 31%, but it went all the way up to 36% last year. I don't know whether that number went up because of there was less protests, or whether the government was making more mistakes because of COVID and quarantines, or whether it's a combination thereof. But overall, we see corrective action taken in more than a third of all protests. When you add corrective action and a successful protest that's sustained together, you're showing a trend where, usually in a 45 to 50% of the time, you're going to be successful when you file a protest. Now, if I were to tell you you have a 50% chance of winning this argument that ties to a must-win opportunity, I think most people would bet on that. So again, you absolutely can win when you file a protest and you head out to GAO. Said the corrective action step is a positive step. And again, like I said, the arguments are worth making because there's about a coin flip on whether or not you're going to get some kind of relief from the government. Next slide, please. I did have debrief and enhanced debrief in my slide deck. I put them in a different place. All right, we talked about that already. We talked about how the pending proposed rule that's out there, it's gonna put in there. What's important for your enhanced debrief is to understand your protest timeline starts ticking when the government answers your questions. So you have a debrief, you send questions in, the government sends responses to your questions, you then have your clock ticking. Now, there has been at least one high-profile protest where a company got its enhanced debriefing questions, got its responses, asked additional set of questions, and the agency answered the second set of questions, and 10 days later, the company protested. Well, it turns out the protest clock started to tick when the first set of questions were answered. So even if the government's willing to respond to additional questions, that's outside of the scope of the rule, and it doesn't impact your timeline. So be very careful if you get involved in back and forth with the government during an enhanced debrief. All right, and aggressive timelines. You know, if you've been involved in a protest, you generally know that the protests, especially at the beginning, are run, and then wait for GAO to make a decision. All right, if you want to file a protest and get an automatic CICA stay, you have 5 days from when your protest clock starts ticking. That 5 days, again, it runs from the close of your debrief or the close of your enhanced debrief. And 5 days to get your automatic CICA stay. CICA is the Competition and Contracting Act. Under that act, if your protest is filed within 5 business days, the agency has to stay the award and actions under the contract. Now, here's where it gets confusing. You have 10 days to be timely at GAO. So if you file your protest on day 7 or 8, you can move forward and GAO will go forward with your evaluating your protest. You don't get an automatic stay, and the agency could continue with the award. Now, a lot of times, especially if it involves a services contract, that is going to you know, there has to be an onboarding and a transition. The agency will delay and give you a stay even though they don't have to, simply because they don't want to have to go through the process twice. If the agency will often, not always, often agree to a stay even if you're outside of the 5 days. But really, I strongly advise my clients, don't chance it. Get your protest filed within that 5-day period. Make sure the stay is automatic. And again, the magic numbers are 5 and 10. 5 is what everyone should have in their mind. Instead of 10, everyone has 10 in their mind. 5 days gets you your automatic stay. If you miss your 5 days, you still have 10. If you miss your 10 days, you stand and you really feel strongly about your protest, and it's worth the extra cost, then you still do have time to go to the Court of Federal Claims, because that gives you a year. Within your protest, you have similarly tight deadlines. Once you get the agency record and you go through the record, you have 10 days to file your comments on the record. So again, these are quick turnarounds. You got to go through the whole record, write an additional supplemental comments on the record, and then raise any new protest grounds within that 10-day period. Again, both times you got 10 days, and then you got 10 days, and then at that point in time, you're probably 45 days in, and you're going to wait another 45 to 55 days for GAO to issue its final ruling. So it's run at the start, and then you get a delay waiting as you twiddle your thumbs waiting for the agency. So again, 5 days is your magic number. Always keep that in mind for your protest timelines. Next slide, please. Okay, so DFARS Part 233 is protests, disputes, and appeals. So we generally focus on protests because that's what comes up the most often. Disputes and appeals covers your claims. Claims and certified claims in the process for filing and appealing those claims. Now, you hear claim, you hear certified claim. A lot of people use those terms interchangeably. In some instances, they are interchangeable. There's one important difference. If your claim is under $100,000, you do not have to certify it. If your claim is over $100,000, there's a special certification you have to attach to your claim that you're certifying your claim basis and the amount you're asking for is in good faith. You have a good faith basis and justification to claim that amount of money. That becomes important because if you don't want to guess when you're signing a certified claim, all right, you don't want to be accused of making a false certification. And this goes with claims in general. Once you submit a formal claim to the government has the option of turning around and saying, well, this is a false claim and I'm going to investigate you for this. Several years ago when I worked at a bigger firm, we represented KBR in several matters. And if you're at all familiar with what KBR went through after the initial Iraq War about 10 or 12 years ago, KBR had a lot of legal disputes with the government. And in several instances, including a matter I worked on, we submitted a claim to the government, and the government then got DOJ involved and said, hey, this is a false claim, you have no basis for it. And it turned into a much uglier dispute. Now, those are rarities. But I will tell you, you don't want to make up and submit a claim based on something you think would be nice to have. Any client I talk to who wants to go down the claim road, I tell them you have to make sure that every penny you're asking for, you can support, back up, and justify. You don't have to be right. The government can come back and dispute and say, no, I disagree with you, here's why. But you do need to have a good faith basis for your claim. All right, you have to have something that ties to change in circumstances, superior knowledge, the government asked me to do extra work, et cetera, et cetera. Those all rate to claims. One other issue that often gets confused here when you get to claims is where the request for equitable adjustment fits in with a claim. Now, the request for adjustment is REA for short, and REA is not a claim. And it doesn't put the government on a claim timeline, and it doesn't require the same specificity that a claim has. You can go to the government and say, hey, you asked me to do a lot of extra work here. I believe you owe me extra money. And a contracting officer, depending on the circumstances, the contracting officer will often, or sometimes anyway, agree with this. It comes up mostly in a construction context where the government realizes it's requesting you to do extra work, but it also, I've seen it in services, contracts, et cetera. The important thing to know is if you submit an REA, it's not a claim. And if you're backing up against your claim timeline, you have to be careful in submitting an REA and then running out of time and not having the ability to submit your claim. So again, claims are a specific, they're governed by FAR Part 33.2 with a little bit of supplemental info and DFARS 233.2. And ultimately it comes out of the Contract Disputes Act. That's a statute that talks about how you can go to the government and submit a claim. And to backtrack on that process, the reason the government has this claims process is there's no way to generally sue the government for breach of contract like you would in a commercial context. If you're a builder and you have a contract to build a building, and then the owner comes in and changes a lot of specs and makes you do a bunch of extra work, you have a breach of contract claim, or you can even walk away and stop working until it's resolved. You don't have those types of options with the government, so you have to go through the claims process pursuant to these regulations and the Contracts Disputes Act statutes. Next slide, please. And I'm now at the point where I'm regretting I forgot to fill up my water cup. All right, so claims. There are specific requirements that are outlined through the Contracts Disputes Act and in FAR Part 33.2. All right, there's certain things you have to do when you submit a claim. It has to be for some certain. You can't say, well, you owe me somewhere around $10,000. No, it has to be, the government owes me $10,326 for this issue. It has to be in writing. You can't tell the government over the phone or in a conversation that you owe me this money. You have to submit it actually in writing, and it has to go to the contracting officer. And generally you write a claim letter, you send it to the contracting officer for adjudication. And if it's over $100,000, again, it has to be a certified claim. You add the certification, and there's a special language you actually need to do to put in the certification. The important thing is you have to file it within 6 years of accrual. 6 years sounds like a very long time. You'll be surprised the amount of times I've seen people mess that up, right? If you are at the beginning of your contract within and you have a a 5-year contract, base plus 4 options, and something happens in year 1 that causes you to accrue some extra work charges, and you wait all the way until your contract is closed out, now all of a sudden you may be outside of your 6-year period. I think most small businesses are on top of this a little bit. This is one area where I think small businesses are a little more price sensitive and a little more revenue and income sensitive, so you stay on top of this a little better than big businesses do. But I've seen too many companies miss the 6-year window for a claim. One time when I was an in-house counsel, I worked for a very large engineering company that actually built ships, and it built a icebreaker for the Coast Guard. The Coast Guard came in and changed all kinds of specs. They accrued $32 million in extra work. They missed their deadline to file the claim. $32 million that company had to eat and walk away from because they started to pursue the claim more than 6 years after it accrued. I'm happy to say I was not the company's counsel at that point in time, but I was the one who had to break the very bad news to the CEO. And let me tell you, you don't want to be the guy who has to call your boss and tell them they have to leave $32 million on the table because somebody missed a deadline to submit a claim. That's an extreme case, an extreme example, but I said I vividly remember making that phone call. It was not pleasant. So again, pay attention to when your claim's accrued, and that's accrued, not finished. So if it starts and you start accruing this extra work, that's when your statute of limitations for your claim is going to run. And the government very strictly enforces that 6-year period. Next slide, please. Okay, so for a claim, the good news is for you, your interest on your claim runs from the date it's submitted. So if it does take 30, 60, 90, or 6 months to resolve, you're at least accruing interest from the date you submit it. All right, so you want to get it in as quickly as you can, as long as it's accurate and correct. Now, the contracting officer, by regulation, they have to issue a final decision on your claim within 60 days. There is one caveat to that, is if your claim is over $100,000 and is fairly complex, the government can tell you within 60 days, hey, I'm reviewing this, it's still under consideration, I am going to get you a response by day X. So the government can extend the 60-day deadline for large claims. Now, there's cases where you can deem it denied if the government keeps kicking the can down the road, et cetera. But generally, you're going to get a response on your claim within 60 days. The government has to either approve or deny your claim or approve it in part, deny it in part. And they have to provide kind of reasons for denying their claim. The government can't just come back to you and say, yeah, your claim's denied. They have to, basically, it's almost like a legal opinion. You submit a claim letter with an argument, a legal argument, why you rate this money. The government comes back, and if they're going to deny it, they have to give you a legal position that supports their denial. So, you generally, then you can take this way, you have you get to understand the government's rationale and what they're thinking of in order for you to be able to make a decision on whether or not you want to appeal the claim. And again, next slide, please. So the appeal, and again, because the government likes to give you options, you have, it's like a choose your own adventure novel. The government gives you two venues to take your appeals down during if your claim is denied. You have the boards of contract appeals. There used to be numerous boards of contract appeals. Each agency used to have their own. Now there are much fewer. There's the Armed Services Board of Contract Appeals, ASBCA. So if you're in a DoD contract, you're going to appeal to the ASBCA. And now there's a Civilian Board of Contract Appeals that has most of the other civilian agencies. There are some outliers with some other agencies, but generally, most likely you're going to be at one of those two. And then there's also the Court of Federal Claims. Much like GAO, the Board of Contract Appeals is a little bit less formal than the Court of Federal Claims. It's not as informal as the Court of Federal Claims. It's still required. It's still a court. It still has a judge. It's an administrative judge, not a Senate confirmed Article 3 judge, but it's still a judge who stands up there on a bench in a black robe. So it looks very much like a court, acts like a court, smells like a court. It's just a slightly less slightly less formal court in that it's an administrative court. You still have to file a complaint, and you get into discovery, and then you go into legal briefings and potentially even a hearing. So if you have to appeal your claim, it can get costly to do so. Generally you try to get your claim resolved with the government at the contracting officer level, because this is like going to court, and even though it's informal, you're talking probably tens of thousands of dollars if you have to go all the way through a hearing with the government. Now, sometimes you'll file an appeal just to take it out of the contracting officer and the immediate agency shop, and to get other attorneys from the agencies involved, and maybe be able to negotiate with some different people who may see things slightly differently than the contracting officer and the supporting legal shop. So a lot of times you'll file an appeal not with the intent of taking it all the way to a trial. You'll try to get into a mediation. Now, by regulation, under FAR Part 33.2, they talk about alternate dispute resolution, which is required in the process of a claim appeal. So the government does recognize this gets costly, and it does try to do it in a more cheap manner. So Board of Contract Appeals is your first option. Court of Federal Claims is your second. I have never, I can honestly say this, I've never appealed a claim to the Court of Federal Claims. Every time I've done it, it's been to a board, and I generally like the boards. And in some aspects, I think the boards are a better choice, because all they do all day, every day, is adjudicate claims. That's their job. Court of Federal Claims does protests. They do vaccine-related things. They do claims. So they do a bunch of claims, and they do them for different agencies. Whereas if you're doing a DoD claim, that's all the ASBCA does. So you're in front of a judge who truly are absolute experts in this process, who've probably done hundreds, if not thousands, of claim appeals. So they're generally my preferred choice for that. But again, you're welcome to go to Court of Federal Claims if you'd like. Next slide, please. Now, so some final parting thoughts on claims. And this is in capital letters. I mentioned earlier. Now, if you're still within your contract POP, if you're still working under the period of performance, you have to continue performance while you go through the claim process. So if you're building a building for the government, and the government comes in and says, you know what, I want you to upgrade to this fancy, highest certified LEED glass for my building, which is 300% more expensive than the original glass, and you want to file a claim for that, well, you still have to put the glass in and follow the government's requirements pending your claim. You as a government contractor do not have the right to walk off the job. You have to continue your performance. If you refuse to continue your performance, you will be defaulted, and you will have bigger problems than your claim. So that's all, and this is a double-edged sword, because a lot of contractors feel like, well, I'm going to wait until I'm done with my job in order to file before I file my claim, because I don't want to argue with my client. And again, that's where you got to watch your 6-year statute of limitations, because it can really, 6 years can sneak up on you quickly. But just be aware that if you're going through this isn't a federal breach of contract or a civilian breach contract where you can say, I'm not working for you until we get this resolved. You have to continue your performance. And again, another foot stopper, beware of the false claim. Don't try to get cute and throw in money that you don't have a very good faith basis to do this. And I'll compare this to a T4C claim. If you're getting terminated for convenience and you need to, get reimbursed for your costs, that's not a claim with a capital C. And a lot of people throw in everything in the kitchen sink in their T4C issue with the government, trying to recoup as many of their costs as they can. You don't want to do that when you get into a formal claim, especially if you have to certify it. right? If you go through that process and you file a claim, and it includes good items that you really don't have a good basis for, the government will come after you for a false claim. All right, and none of us want to go down that road. That gets very ugly, very messy, expensive to defend, and if it goes south, it involves prison time, right? So this is, what I talk about in the claims. I'll use a football analogy. You never want to be the wide receiver who's dragging your toes trying to stay in bounds when you're figuring out what you can claim. You want to be the guy who's crossing over the middle of the field, who's not even close to the edge, which means, if you need to leave a little bit of money on the table in the process to avoid the specter of a false claim, then I definitely recommend that you do so. And that's kind of my final thoughts on claims. Next slide, please, Hunter. And again, that's me. That's a youthful me with more hair and a bright smile. But that's my contact info. So if you have any questions or want to follow up on this or anything else government contracted related, feel free to reach out. And at that, Hunter, I will give you the keys to the kingdom.
Thank you, Louis, and thank you for a great presentation and sharing your time with us today. And as he said, make sure to reach out to him if you have any questions about what was presented today. And thank you to everyone who joined us for this webinar. The recording will be on our website and YouTube channel within the next 24 hours. And please join us next week on Wednesday at 12 p.m. Eastern as we cover more parts of the DFARS. Have a good one, everyone.
All right. Thank you. Bye.